Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular set of videos, we're talking about naturalization and the requirements. So another requirement is you must be 18 years or older in order to apply for naturalization, although there is an exception to that regarding military statutes, but for the most part, you do need to be 18 years older, and you must meet the continuous residence and physical presence requirements. The bottom line is that if you're not in the United States more than you are in the United States, they just don't believe you really want to become a U.S. citizen. And then, of course, there's the issue of security and intention and all of that. So you do have to meet these requirements. So now, once you receive lawful permanent resident status, that's when the time begins to show that you have continuous residence. Now, you must have been a continuous resident for 5 years subsequent to lawful permanent resident status. There is an exception to that. If you marry a U.S. citizen, and of course when you apply for citizenship or naturalization you're still happily married, then the continuous physical presence requirement is only 3 years. So if you're married to a U.S. citizen, in order to get this 3-year continuous physical residence requirement, one, the USC spouse was your spouse for at least 3 years, and that you are living in marital union, which means that if at the time you apply for naturalization there is a divorce, a legal separation, or even an informal separation, that would all signify the dissolution of the marital union, and you would have to wait the 5 years in order to apply for the naturalization. Now, keep in mind that a spouse is only required to be living in marital union for the 3 years immediately preceding the date of the filing for the application. This means, of course, that if it's outside this time, that generally you will not need to have the 3 years. So then the question becomes, if there's a marital dissolution, for example, at the time of the interview, but it's outside that 3 years prior to the filing of the naturalization, then some jurisdictions will state you still qualify for this exception, and others will say you don't. So it just depends. Okay, more on the coming video.